Louisiana Real Estate Exam Part 2 2025, 100 questions with explained answers. Question 1. Agent Anna shows a home to the Quinns without a buyer's agency agreement. The Quinns are clients, fiduciaries, principals, customers. In real estate, there is a major difference between a client and a customer. A client has a signed agency agreement and is worked for by the agent. A customer has no agreement and is worked with. Agents owe customers honesty and disclosure of material facts, but not fiduciary duties like loyalty or confidentiality. Question 2. Which duty requires a licensee to follow a principal's legal and ethical requests? Obedience, accountability, disclosure, honesty. The fiduciary duty of obedience requires agents to follow all instructions from their client, the principal, provided those instructions are legal and ethical. If a client asks an agent to do something illegal, like discriminate, the agent must refuse or terminate the relationship. Question 3. A seller asks Melissa, their agent, legal questions she thinks she knows the answers to. Melissa should suggest legal counsel, answer the questions, find out and get back to them, say she isn't sure. Real estate licensees are specifically prohibited from practicing law without a law license. Giving legal advice, even if the agent is certain they are correct, can lead to lawsuits and loss of license. Agents should always refer clients to a qualified attorney for legal matters. Question 4. Agent Terry sells a property under market value to his brother without disclosing the relationship. This is wholesaling, creative agency, steering, self-dealing. Self-dealing occurs when an agent acts in their own interest, or the interest of a close associate/relative, rather than the client's. Agents must disclose in writing if they have any personal interest in a transaction, including being related to one of the parties. Question 5. A seller decides 1 week before closing they no longer want to sell. What could happen? Broker owes a commission, buyer owes a commission, agent earned no commission, seller owes a commission. When an agent produces a ready, willing, and able buyer whose offer is accepted, the agent has legally earned their commission. If the sale fails to close because the seller defaults, changes their mind, the seller is still contractually obligated to pay the broker's fee. Question 6. A sale between unrelated parties acting in their own self-interest on the open market is a/n. Fair market value, sale under duress, arm's length transaction, non-homogeneous sale. An arm's length transaction is one where neither party has a prior relationship or undue influence over the other. This is the standard for determining true fair market value, as it ensures the price wasn't artificially lowered due to family ties or high-pressure tactics. Question 7. How is real estate legally defined? Land and items within improvements. Land, water, air, and improvements. Properties sold between parties. Commercial and residential land. In legal terms, real estate includes the physical land, surface, the subsurface, minerals, the airspace above, any water rights, and all man-made improvements like buildings, fences, or sewers that are permanently attached to the land. Question 8. A fence that accidentally extends onto the land of a neighboring property is a/n. Encumbrance, easement, encroachment, escheat. An encroachment is a physical intrusion of an object, fence, driveway, tree limb, onto another's property. This is a form of trespass and can create clouded titles that must be resolved before a property is sold. Question 9. Marvin has an easement to use neighbor Bob's driveway. Marvin's property is the servient estate, life estate, dominant estate, freehold estate. In an easement appurtenant, the property that benefits from the use of the neighbor's land is the dominant estate. The property that is being used, and therefore burdened by the easement, is the servient estate. Question 10. Federal law requires the disclosure of lead-based paint in homes built before 1965, 1978, 1992, 1980. The Residential Lead-Based Paint Hazard Reduction Act of 1992 requires sellers and landlords of homes built before 1978 to disclose the presence of known lead-based paint and provide buyers/tenants with a federally approved lead hazard pamphlet. Question 11. A property manager is told by the owner to reject all applicants with children. The manager should comply with the owner, refuse and explain fair housing laws, follow wishes quietly, approve only childless applicants. Familial status, having children under 18, is a protected class under the Federal Fair Housing Act. Discriminating against families is illegal, and a property manager must follow the law even if the owner, the agent's principal, demands otherwise. Question 12. What is the accumulation of land caused by the natural flow of water called? Erosion, accretion, evulsion, alluvion. Accretion is the process of land increasing due to the gradual, natural action of water, like a river depositing silt. The actual soil that is deposited is called alluvion. The opposite of accretion is erosion, where land is worn away. Question 13. Donnie leaves a home to his wife for her life, then it goes to his son Logan. Logan is the life tenant, grantor, remainder man, leaseholder. A remainder man is a person who has a future interest in a property that will begin when a life estate ends. In this case, Logan owns the property's future, but he cannot take possession until the life tenant, Trish, passes away. Question 14. Matt is listing a home built in 1965. What specific disclosure must he have the seller complete? Lead-based paint, mold, radon, asbestos. Because the home was built before 1978, federal law mandates a lead-based paint disclosure. The agent must ensure the seller completes this form and the buyer receives it before a purchase contract is legally binding. Question 15. A form covering home components and the seller's knowledge of their condition is a home inspection report, seller's condition report, listing amendment, seller's disclosure. The seller's property disclosure is a standard form where the seller lists known defects or repairs. While it is not a warranty, it serves to protect the seller from later claims of fraud and helps the buyer make an informed decision. Question 16. Buyers waive an inspection and later find a defect the seller truly didn't know about. Is the seller at fault? Yes, must disclose all issues. No, seller had no knowledge. Yes, must provide inspection. Yes, must pay for repairs. A seller is only required to disclose known material facts. If a defect is latent hidden, and the seller had no knowledge of it, they are generally not liable. This highlights why buyers are always encouraged to perform their own professional inspections. Question 17. A seller knew about termite damage but hid it from a buyer who waived their inspection. Is the seller liable? No, waiving inspection means acceptance. Yes, for failing to disclose known defects. No, unless the agent pays. Only if the lender agrees. Waiving a home inspection does not give a seller permission to lie or hide known material defects. If a seller intentionally conceals a major issue, like termites or a leaky roof, they can be sued for fraud or misrepresentation even after the sale is final. Question 18. An inspection reveals roof issues previously unknown to the seller. What should the seller do? Drop the price drastically. Update the seller's disclosure. Tell buyers only if they ask. Repair the roof immediately. Once a seller becomes aware of a new issue, usually through a buyer's inspection report, that issue becomes a known material fact. The seller must update their written disclosure form so that all future prospective buyers are aware of the roof's condition. Question 19. In which type of transaction is a seller's property disclosure generally not required? Residential arm's length, triplex purchase, residential foreclosure, mobile home purchase. In a foreclosure, the seller is the lender, a bank, that has likely never lived in or even seen the inside of the home. Because the bank has no personal knowledge of the property's history, they are typically exempt from completing the standard disclosure form. Question 20. A listing agreement in writing creates which form of agency? Negligent agency, implied agency, express agency, ostensible agency. Express agency is created when the principal and the agent express their agreement in specific words, either orally or in writing. A written listing contract or buyer's agency agreement is the most common way to establish this relationship. Question 21. A deed restriction prohibiting property transfer to a protected class is legal, void and unenforceable, valid in court, standard practice. Discriminatory covenants, example, no sales to a certain race were ruled unconstitutional and are a direct violation of the Fair Housing Act. Such clauses are legally void, meaning they are treated as if they do not exist. Question 22. A fiduciary who holds or controls property for the benefit of another is called a trustee, grantor, beneficiary, grantee. A trustee holds legal title to an asset for the benefit of a third party, the beneficiary. This is a high-level fiduciary relationship where the trustee must manage the property according to the specific instructions of the trust. Question 23. A contract between two parties where both give a promise for a promise is unilateral contract, bilateral contract, special agreement, collusion. Most real estate sales contracts are bilateral. The buyer promises to pay money, and the seller promises to deliver the deed. Both parties are legally bound to perform their specific promises. Question 24. An open listing seller pays only the broker who brings the buyer, is what type of contract? Bilateral contract, unenforceable contract, void contract, unilateral contract. A unilateral contract is a one-sided promise. In an open listing, the seller says, "If you bring me a buyer, I will pay you." The broker is not promising to find a buyer, but the seller is promising to pay if the result is achieved. Question 25. To be enforceable, real estate contracts must be in writing according to the Real Estate Commission, Statute of Frauds, Federal Real Estate Act, Sherman Antitrust Act. The Statute of Frauds is a legal doctrine requiring certain contracts, including land sales and leases over 1 year, to be in writing and signed to be enforceable in a court of law. Oral agreements for the sale of land are generally voidable. Question 26. Which of the following is not a requirement to enter into a real estate contract? Parties must be U.S. citizens. Parties must have proper authority. Parties must be mentally competent. Parties must be of legal age. You do not have to be a U.S. citizen to own property or enter into a contract in the United States. However, parties must have legal capacity, meaning they are of sound mind, of legal age, 18, and have the legal authority to sign for the property. Question 27. A valid contract must contain valuable consideration, which means no personal property items, cash only, something clearly offered for something else, none of the above. Consideration is something of value exchanged between parties to seal the deal. While it is usually money, it can also be goods, services, or a promise to do, or not do, something. Without consideration, a contract is not legally binding. Question 28. To convey ownership in a property transaction, the contract must include surface rights, a legal description, rights of survivorship, the full bundle of rights. A street address is not enough for a legal transfer of land. A contract must include a legal description like metes and bounds or lot and block, that allows a surveyor to identify the property's exact geographic boundaries on the earth. Question 29. Which of the following is not a requirement for a contract to be valid and enforceable? Competent parties, authority, notarization, Valuable consideration. While deeds are typically notarized so they can be recorded in public records, a basic contract between a buyer and seller does not require notarization to be a valid, binding agreement between those two parties. Question 30. When someone is forced into a contract by intimidation or coercion, it is called bullying, duress, stress, strong-arming. Duress occurs when a person's free will is taken away through threats or force. Any contract signed under duress is voidable by the victim, meaning they can choose to have the court cancel the agreement.